big fan of new techniques. In fact, I will speak about the position of the children in the Rome Statute and in practice of the International Criminal Court. See? And in fact, let's see where can we find the notion of children in the Rome Statute. On the one hand, there is a very nice paragraph in the preamble, but after that we are going to the different crimes. And so in Article 6 about the genocide, which is just the same text as the 1948 Convention, the fifth version, the forcible transfer of children, is kept as one of the form of the genocide. Among the crimes against humanity, this is the enslavement where the children are mentioned, you can see. They are mentioned also among the war crimes. This is the child soldiering. The text is the same, but maybe you know that the war crimes are divided into two pieces. The first part, this is for international war crimes in international conflict, and the second part is devoted to war crimes in a non-international conflict. But the text is the same, in fact. And here what is very important, and I will turn to that from the point of view of child soldiering, this is the... Okay, I hope that I could use this with the infra light, but apparently it does not work on the screen. Sorry for this. So anyway, here this is 15 years, which is the time limit. However, when we are speaking about the penal liability of young people there, the age of the children is 18. And this has also certain consequence for our practice. If we go further, in Article 21, this is the sources for the International Criminal Court. This is more or less the same like Article 38 of the International Court of Justice. But as you know well, at the ICJ, the different sources are at the same level, so there is no hierarchy. However, within the Rome Statute, there is a certain hierarchy, and so there's in the first place, the statute, elements of crimes, it's an interpretative document, and the rules of process evidence. In the second place, where appropriate, applicable treaties and principles of international law, and failing that, the general principles of law. But what is very important for us, this is paragraph 3, because there is a wording that the application interpretation of law must be consistent with internationally recognized human rights. And even if we could find human rights also among the applicable treaties, but according to our interpretation, it's a bit an lex specialis position, the Article 3, and it gives us the possibility to use the jurisprudence of the human rights tribunals, whether this is the European Court of Human Rights or the Inter-American Court of Human Rights, or eventually the African Court. When judges are nominated and elected, or when the prosecutor is chosen among the candidates, from among the candidates there, their devoteness to the children's interest is taken into consideration. It does not go forward, okay. Okay, so yes. So I was here, and yes. Children are mentioned also among the duties of the prosecutor and its staff. You can see that with right. And the participation of witnesses. There we can find once again the allusion on children. And we find that also in the article concerning revision of the conviction of sentence, where this is the children of the condemned person who is entitled to ask the revision. And there are a number of documents prepared by the prosecutor, and we call that policy papers. There are a good dozen from that. This is not legally binding, but in fact this is always a good recapitulation of the prosecutorial practice from different point of view. And there, in 2016, there was already a policy paper on children, and this was renewed last year. And there we can find, in fact, 6 objectives and 7 principles. And here what is apparently the most important is that the office should have a child-competent, child-sensitive approach, and this is the best interest of the child which should be taken into consideration. Here you can find the wordings and the notions imported from the International Convention of the Rights of the Child. There are 7 principles. In fact, these are only the principles that I quoted. Between the different principles, there are, in fact, technical proposals how it should be done. And in fact, to take a survivor-centered trauma-informed approach, proactive consideration and engagement with the children. In fact, these are more or less the same techniques and the same rules which were mentioned today by Professor and the Secretary of State Lucia Kurilovska, so that we should follow the principle of do no harm. We needn't repeat again and again the hearing of the witness, especially if he's a child and especially if he was a victim of a sexual or gender-based crimes. So one hearing is enough and is registered. And in the subsequent stages of the procedure, let's say on trial level, we can use that video footage which was made in pre-trial stage about the testimony of the victim. The do no harm principle you can see in another policy paper. And in fact, there are several papers which emphasize the need to take into consideration that the crime is committed against children when we are, or when the prosecutor is trying to find the proper case from a situation. Because you know well that before the International Criminal Court, these are situations which are referred there by the given state or by state parties or eventually by the Security Council, and from among the situation, some distinct cases should be chosen by the prosecutor. It was settled in that way during the Rome diplomatic talks in order to grant the full impartiality and independence of the prosecutor. And the importance of the gravity assessment, maybe I should wait here. Yes. So it appears in other position papers as well. Yes. In the policy paper on victims' participation, in fact, there were the 2 most important principles is that if the victims are children there, the indirect victims could have also a certain right to act before the court. And in fact, indirect victim, these are very often those members of the families who were living together with the child who disappeared or who passed away during the hostilities. And in fact, the right of participation of legal persons, mostly the schools, which is important for them, from this point of view. You know that there is a certain cooperation between the ICC and the Eurojust and the other institute of the European Union. And there it is once again mentioned that the rules and principles protecting children should be taken into account because of their particular vulnerability. This is once again the manifestation of the do no harm principle and the need to register the testimony when it's already possible. In fact, there are several situations where the prosecutor is working tirelessly also concerning the rights of the children. And there you can see Uganda, Australia, Venezuela, Colombia, Philippines, Israel, and the Palestinian Authority, and Nigeria. Concerning Australia, these are the indigenous people's children who are considered. Concerning Nigeria, this is the children kidnapped by the Boko Haram. You have certainly heard about that. And concerning the investigation activity, it's well known that in Libya, Ukraine, Russia, Sudan, and Afghanistan, the prosecutor is very active. And it happened a couple of days ago that maybe 6 state parties to the Rome Statute called the prosecutor to go further in the investigation, the Afghanistan situation, where you know that girls are quasi forbidden from education, or it's on a very basic level that they have the right to be scholarized, and after that there is nothing. And so this is the and concerning Russia, you know well and that there the those let's say 2 arrest warrants which has already been issued concerned the forcible transfer of children. So according to the perception of the prosecutor, so from Ukraine territory into Russia, and there they are, let's say, adopted by Russian families, or they are brought up in different institutions, as the prosecutor says. In the strategic plan of the Office of the Prosecutor, once again, the children issue is mentioned, and the best interest of the child-sensitive and child-competent approach is mentioned. So here, once again, we can find those notions which will be developed later by my colleagues dealing with the UN Convention on the Rights of the Child. Yes. And in fact, these are the cases where we met with the different issues of the crimes committed against children. First, this is the child soldiering. You remember that the use or involvement of children under 15 is a crime according to Article 8 of the Rome Statute. And when I was not yet at the court, I did not really understand why the child soldiering is so important for the court. And since I have been there, I understood this well. So it is something unbelievable that different militias are kidnapping children, and they brainwash them, and they succeed to build up a kind of, let's say, killing machines without fear and favor. And so young guys, so children with Kalashnikov are killing adults just for fun or for order, of course. And so, and in the Lubanga case, sorry that my infra point does not work. The Ituri region is about here. Oops. So on the northeastern part of the Democratic Republic of Congo, and In fact, the Lubanga case and the Taganda case is linked with that. Mr. Lubanga, he was the leader of a militia, and Mr. Taganda was his deputy. He was the chief of staff. Mr. Lubanga was charged only concerning the child soldiering. Mr. Taganda was charged not only with the child soldiering, with other crimes as well, and also concerning the crimes committed against the child soldiers, because it happened very often. And in the Ongwen case, this was similar. So in Uganda, by the way, very close once again to this Italy region, that especially girls who were kidnapped. So first they were acting as things, figurative babysitter, but in fact slaves having to deal as a domestic slave with the jobs of the families of different warlords. And when they reached their maturity, the time they were distributed to different commanders for their brevity, let's say. And so, in fact, so many children, I mean, these were 13, 14, or 15-year-old young girls. In fact, daytime, they were working for the militia. They were transporting ammunition. They were sent as messengers. They were sent as in order to spy about the movements of the other factions. And in the night, they had to serve as, let's say, wife, once again, figuratively, of the different commanders. Mr. Lubanga was condemned for 14 years, if I remember well. Mr. Taganda was condemned for 30 years. Mr. Ongwen was condemned for 25 years of imprisonment. The question of the child soldiering comes back also in the Yekaton Gaisona case. This is a case where I am involved, and I cannot speak about that because it's still pending. It was already mentioned by Ombudsman Miklosko, the importance of the transgenerational harms. And when we met with that, the first occasion in the Katanga case, we said that, well, we are not totally sure that this is the court which should pass a decision about the transgenerational harms. You know that there are two schools explaining the transgenerational harms, the so-called epigenetic school, which supposes that some modifications, malformations of genetics can be felt as the reason of different harms appearing already in peacetime in the descendants. And there is another school, let's say a social behavioral school, which explains all this rather with social interactions between mother, father, and the descendants. And anyway, in Katanga, because Mr. Katanga was acquitted from above the charge of rape, that's why there the transgenerational harms, this issue was only shown in an abstract way without consequences. It came back in the Taganda case and Ongwen case, also concerning the reparation issues, and there we stated that yes, this can exist. We cannot presume during the reparation phase that it happened effectively, this transgenerational harm, but if the given victim can prove that, he will be also entitled to reparation. And we have to take into account also the perpetrator's own childhood past, and this happened in the Ongwen case. Mr. Ongwen's father was a teacher and priest, a very, very correct gentleman in Uganda, and Mr. Ongwen was kidnapped when he went to school at an age of about 11 years old, and after that he he was taught in order to become a warrior, and he went higher and higher in the military hierarchy of the militia. Finally, he was one of the generals of the so-called Lord Resistance Army. And with that, in fact, he was the leader of one of the division, acting under the supreme commandant of a certain Mr. Joseph Kony, a person who, let's say, a charismatic person who tried to make a kind of a mixture from some basic notions of Christianity and some local beliefs of Uganda. And by the way, he left Uganda and he is somewhere in South Sudan or in Sudan, and from this he is directing the Lord Resistance Army. And by the way, he is living Kazi in a harem with about 80 girls, 80 ladies, all kidnapped, because in fact Mr. Kony wanted to establish kind of a new generation of the Acholis. And he and also the subordinate commanders made so much in order to procreate new warriors for the Acholis population. Children's unlawful deportation on transfer. This is an element of the situation in Myanmar. Maybe you have heard that our prosecutor, Mr. Karim Khan, asked mentioned that in a couple of days he will submit a proper arrest warrant against Mr. Ming Aung Hlaing, the acting head of state of Myanmar, former high military commander of the country. And concerning the situation in Ukraine, you know that the competent pretrial chamber approved the prosecutor's submission on arrest warrant against Mr. Putin and against the Ombudsman for Children's Rights, Madame Belova. In fact, the prosecutor emphasizes the importance of the child-relating way of thinking of the institution, that the child-sensitive, child-competent approach should be maintained, and this is the best interest of the child, which should always be in the focus and in the center of the attention. In fact, we can okay, maybe I think that it went back. if I understand well my papers. But anyway, those documents. Yes. Oh, sorry, Okay, and so in fact what is very important, this is the fact that we are not only condemning perpetrators, but in fact we are also trying to improve their situation. And so that's why the reparation and the assistance activity is very important for us and also for the victims. And in fact, the difference between the reparation mandate and the assistance mandate, both are under the umbrella of a special autonomous institution called the Trust Fund for Victims, are very important. Concerning the reparation mandate there, this is the condemned perpetrator who is in the center of the obligation to repair the harm that he caused. And concerning the assistance mandate, there the trust fund is acting rather freely. And it is used when the perpetrator hasn't been condemned, he was acquitted, he was not found, but the victims need a certain care. And concerning the children, in fact, they have their special need that we should observe well. As I mentioned, Mr. Ongwen was kidnapped when going to school. And after that, there was no scholarization for him. And so you can imagine what is the market value of someone, even if he is undergoing to a disarmament and demobilization processes made by the local government with the help of the UNESCO, of the World Bank. So when they are trying to teach them to live in a peaceful manner, in a peaceful community, without military actions. Okay, this program is rather short, a couple of weeks, but after that he should do something with himself. And in fact, but he has already lost a couple of years of schooling. And so, in fact, the Trust Fund for Victims is preparing teaching programs for these formerly abducted girls or boys, and they are, and the Trust Fund is trying to give him certain type of professions, which has an importance also on the market value. This can be also different profession in agriculture, in husbandry, also in commerce, also in artisanal activity and so on, or tailor jobs and tailor profession for girls, or how to manage a small restaurant and so. So these type of programs are managed by the Trust Fund for Victims. And beside that, the Trust Fund for Victims is acting also in order to try to repair the harm suffered by the children or by the former children. And you can imagine the difficulties to treat them against the HIV. So those who had to serve as wives of different commanders, or those who were flogged because of their disobedience, or those who had to consume different types of cannabis and other drugs. So in fact, a huge amount of money is needed to that. And this is the Trust Fund for Victims, whose job is to collect the money from governments, from private individuals, also on behalf of legal persons, and to organize all the schooling, medical, psychological, and other programs, which is contributing to the correct way of life for these children who suffered so much during their past. And so, in fact, because of the vulnerability of the children, they should always be in the attention of the court, and we can see that that this special attention that we pay on the interest of children during the case selection, pre-trial, trial level, or later during the reparation and assistance after they justify, even more because there are so many problems which are linked with the harms caused to the children, and this is a fact of the recurrence of the hostilities and of their transboundary extensions. Maybe you remember that I invoked a certain Mr. Taganda, as he was the deputy of Mr. Lubanga in the DRC case. Mr. Taganda, he was not a child soldier, he was a young guy, 16-year-old maybe, who was born in Rwanda, and he was a Tutsi. He survived the big genocide massacre of the 90s, and because of the ethnic similarity of the Hutus and Tutsis in Rwanda, and Lendus, Gitis, and Hamas in the DRC, So in fact, Mr. Taganda, as a Tutsi, wanted to help the Hema community of the Ituri region in order to protect them from those who considered as being quasi the same like the Hutus. So once again, this is not an easy issue, and so it's very important to take into consideration that it's very important to stop the hostilities, if possible, and if not, anyway, to secure the normal life of the children when they are already out of the power of these militias. And thank you very much for your attention.